Not about admission of guilt. It's not about discussing merit of contracts or merit of employees. And that's a whole other conversation and matter that we're not here tonight to decide. It's very specific, excuse me, it's very specific around the consideration of cure or correct. That's all it is. It's just the decision. Do we as a board want to correct actions without admitting guilt, without discussing anything else except for the fact that we want to, be responsive to the community and take those steps.
Madam President, I have a couple questions for you. By your procedure, should my motion fail and yours be adopted, because we are considering my motion first and then yours, that's the order of precedence. You've indicated that placing the contracts on the agenda satisfies the cure for Wendy Lax. It does not, because her cure was that the extensions be rescinded. So even your motion will not satisfy, will not cure, potentially will not cure Wendy Lax requirements. Also, I believe that because you placed the information on the agenda previously, that regarding when the board was going to go into closed session, that we must acknowledge that there is the potential of litigation from employees who feel that their contracts have been wrongly invalidated. And while you are concerned about the about the concerns of our community members from a litigation standpoint, I personally am also concerned about litigation against the district by valued employees, and I am concerned about the representation that the Board of Education doesn't value the agreements that we've established with our employees, whether they're administrators or classified individuals or credentialed individuals.
Okay, couple points is the cure and correct from Ms. Lack is simply saying that not that we rescind contract. She's suggesting that we ensure that the language is compliant with requirements of AB 1344, that we have a properly noticed meeting, we provide copies of the contracts, and that's what we do by placing it on the agenda. We attach the contracts in a properly noticed meeting. The board shall vote to approve or deny contracts. She's not suggesting, and let me finish that, Ms. Mayo, because you had asked me these questions. We're not voting, she's not suggesting, as I read this, that any contracts be denied. The act of, it's simply putting them on a properly noticed, regularly scheduled meeting. No, and I'm going to maintain for you that the placement of those contracts absolutely corrects the action. And the placing of those contracts is not about, by placing contracts on a public agenda, let me say this, there is no breach of contract. There is no breach of contract for employees simply by placing contracts on the public agenda. So that's not where a breach occurs. Where you would ask me about a breach, Mrs. Mayo, and I'm trying to respond to that.
For the record, I'm looking at page 2 of Wendy Lack's letter. In the second paragraph, parens 1, in a properly noticed public session and placed on the agenda, the board shall rescind approval of all contract extensions.
It is not placing the contracts, I'm going to say it again, placing the contracts on a public agenda does not mean that contracts are not approved. We're placing them on the public agenda to correct what is perceived as a missing step, and the missing step was that we didn't place written contracts on a public agenda and hold a public discussion. And that's the correct part. The merits of the contract are not in question at this stage of the game. It's really, do we want to correct what they're suggesting has been an oversight, that those contracts were not placed on a public agenda for public discussion. And you can ask 3 attorneys and get 3 different opinions. But the point being, some attorneys will argue that in April, that conversation was simply a verbal agreement around extensions. There was no violation of the Brown Act on April 23rd because on the agenda that night it said, consider contract extensions. Well, that's what the board did. What the concern is after that is whether or not the public had a chance to see those written contracts and have the board hold a proper discussion of those contracts. So some will maintain, and attorneys will maintain, that a violation could have occurred once employees began signing those contracts. But this is simply, again, we're getting into the issue of guilt or innocence. It's not about guilt or innocence. It's about, can we do it better? And simply placing those contracts on the agenda does not give employees cause for breach of contract. It's not saying employees are not worthwhile. It's saying we need to go back and hold that public discussion in order to satisfy the cure correct. Hold that public discussion that we didn't have and give the public the opportunity to comment on where their money's being spent. This is public funds, public contracts. It's not about the merits. It's not about the guilt or innocence here. It's not about the merits of employees. That is not what the discussion is. The question before the board is, do we want to correct it without acknowledging any guilt, without being concerned about guilt, without diminishing employees? Do we want to allow the public to have that chance and thus eliminate all possibility of community members filing lawsuits? And that's what I'm suggesting that we do, and that's why I tell you it's for no risk to the district whatsoever.
We are not required to concur with the demand to cure and correct.
No, we're not, but we put the district in a position where if we choose not to correct, this action, then as Ms. Brown said, community members can sue the district. Should a court decide differently, and we're not a court of law here, the district becomes liable for attorney's fees for that person, not to mention the fact that as I see it, we have now dragged this on into a public arena where what we can do tonight is simply take steps to correct it and let it go and move on. And by continuing this, we are actually in one sense taunting community members, saying we know it's simple to correct it, but we're going to choose not to. And we're going to choose to drag this on longer, at which point, again, community members can opt to sue the district. They can seek attorney's fees. We now get into this issue of if a court sees it differently and sees that there was a violation of the Brown Act, then we are liable for attorney's fees, and the court can issue an injunction which would require us, for example, to record closed sessions and make those available to prove that we are not committing future Brown Act violations. It's a simple matter. It's a no blame, no harm decision to say we simply put those back on the agenda, and the very act of placing them on the agenda cures and corrects the action. And it's that part is finished, and people cannot return and say we didn't correct it. Once you've corrected it, it's corrected.
Can you clear something up for me? It's going to go on the, if we put we put them on the agenda, and then we bring it up for discussion. What exactly are we going to be discussing?
The board, they're asking that we discuss these contracts. The public has the right to comment on contracts that
we're just going to go through the details of the contract and then discuss it. And then when we finish that discussion, then what happens?
Then we look at the cleaned up version, and this board, as you know, we discussed last April, this board would make the decision, and it can simply be to validate. We now have cleaned up revised contracts. It can be to accept that. The board can decide to do whatever it wants to do as a board, just as they did last April. But the part that we correct is the public discussion of those contracts. It doesn't